Thank you very much, Mr. Chair, and thank you, distinguished members of the committee, for your very thoughtful and thorough questions. Continuing on, I think it would be best to now move on into the topic of children's rights and the wrongful removal of children. So what Ms. Janina raised with respect to Article 25 of the Convention, that there is a recognition of, let's say, three scenarios. Perhaps this is a laguna within our laws, that there is no specific provision, as we stated in our state report, as well as our reply to the list of issues, in dealing with respect to the issues, the cases when children are subject to enforced disappearance themselves, or when their parents are subjected to enforced disappearances, or when they are born in captivity. And so we seek and we look forward to your detailed comments on this. But as we also explained within our own legal framework, is that we do have provisions in the criminal code which we believe adequately punishes and holds those who are liable accountable. In addition to the article and provision within our criminal code regarding unlawful imprisonment, we also have Article 327 of the criminal code that states that taking away a minor from the person who has legal custody shall be punishable by imprisonment. We also have further elaboration, the offense shall be punishable by imprisonment from 1 to 3 years if the minor is kept outside the territory of the Kingdom of Cambodia. And we also have Article 9 on the law of suppression of human trafficking and sexual exploitation that states that a person who unlawfully removes a minor or a person under general custody or curatorship or legal custody shall be punished by imprisonment from 2 to 5 years. Furthermore, if the removal is intended to make profits and exploit and make profits, Article 10 states that a person who unlawfully removes for profit-making, sexual aggression, production of pornography, marriage against will, adoption, or any form of exploitation shall be punished from 15 to 20 years. So this, when the victim is a minor. This is as an aggravating circumstance. With regard to the procedure of adoption, I'd like to pass the floor to Excellency Kirin from the Ministry of Justice, and he can discuss regarding Cambodia's path in dealing with, at times, this issue of inter-country adoption. Excellency.
Thank you, Mr. Head of Delegate. So, in terms of inter-country adoption, I think if go a bit on the background of the adoption of this law in 2007, in 2nd January 2007, actually the Kingdom of Cambodia is a party to the Hague Convention on Protection of Children and Cooperation in respect of inter-country adoption. And follow this enter into this convention, Cambodian enter into have took an opportunity to adopt the law on inter-country adoption to set up a legal framework and mechanism procedure to how to provide an inter-country adoption. I think before this, we, based on our historical background, after the Pol Pot regime, a lot of offense. So how we deal when we do have not infrastructure? So we try just only set up an orphanage center, fund a small amount of whatever we have from the scratch. We have not much people to assist. So sometimes we provide a family, relative family to take care of that orphan, to be their own child, for example. And after that, when we are progressive a bit, we come up with or establish an orphanage center run by the government, and also we allow to have a private sector to assist on this. So since then we much manage and also provide them an education, healthcare, whatever. We try our best when we are also surrounded by economic sanction, when we are victim of atrocity, and also we don't have any seat at the United Nations after the 1979 until 1993. So this is our struggle that we deal with the children. It's very sad for us, but we try our best to entertain and also to take care of those children. Come up with this, and then after that we have a lot of demand from the abroad to take care. Sometimes we have also the tourists want to visit orphanage center to provide some fund, and also want to take care to bring them to have a better education in the third party, especially in Europe and in the USA, whatever. We at that time we don't want to provide such an adoption. This is our beginning of our commitment that we don't want to provide any adoption from the foreigner country. So after that we discuss and also have to set up first regulation in terms of broadcast to provide inter-country adoption. Then we first a challenging of, I think, because the perpetrator will not consider whatever the child, but they just only try to exploit those. That's why we come up with enter into the Hague Convention to have some standard and practice and also best practice, and then we have set up an inter-country procedural adoption. Last time we have also some adoption case that we are suspicious of child trafficking. That's why we suspend some process from many countries, maybe from Europe and also from the American continental. I could not specify any state, but in terms of owner, so I just only we stop it, and then we also try to have set up as my colleague from the State of Interior also to look into in consideration of combating and preventing of human trafficking, including child trafficking. So this is I could highlight of what is our struggle and also our commitment in order to make sure that the child is protected, because we suffer a lot during the Pol Pot regime and also the remaining after that period of time. Because I was not in that period, but I was in the during that we have a lot of. I can say that I was growing during the bombardment. They call a boy under the civil war, so we suffer a lot. Thank you.
Thank you, Excellency. I'd like to invite Lokchumtir Longsonita to discuss the law on child protection. But before doing so, I have actually been involved in the drafting of this law as well. In my second life, I'm a Secretary of State at the Ministry of Telecom, and so we deal on digital matters, and so we've been actively participating in the drafting of this law. We mainly deal with the chapter on online child protection. And so from what I can say is that this law, we've been working closely, the working group, this is led by the Ministry of Social Affairs, closely with UNICEF in the drafting of this law. But I'd like to invite Lokchumtir Longsonita to provide more information and an update on the status of this law.
Thank you, Head of the Delegation. Concerning the protections of children in Cambodia, we have not forgotten the inquiry from Ms. Janina, so allow me to briefly touch upon that. A brief background, if you allow me. Cambodia is one of the leading countries in leading the fight against violence for children. Actually, it's the only 3 countries in the region who is a member of a pathfinding countries, and what it means is that it's those countries that the leaders make formal and public commitment to comprehensive actions to end all forms of violence against children, and to request by becoming a member with the Global Partnership to End Violence Against Children. The government of Cambodia also commits itself to the Sustainable Development Goals number 16.2 for ending violence against children by 2030. We have also tasked the Cambodian National Council for Children to conduct a study online regarding, my apologies, to conduct a study regarding the online sexual exploitations of children in Cambodia, as Excellency Head of Delegation has mentioned in one of the chapters of the draft law. The Cambodian National Council of Children also launched the guideline on online child protection to continue to further the awareness raising by mentioning the risk and introducing a holistic approach to respond to the threat and dangers that children may encounter online. The government of Cambodia has also developed numerous policies, laws, strategic plans, and national actions plans, nationally and sub-nationally mechanism to implement for the purpose of coordinating, reviewing, and monitoring the children's progress and challenges that they may face. Some of the national mechanisms that I can mention are above: the Cambodian National Council for Children, the National Child Protection Commission, the National Committee on Child Labor, in addition to these mechanisms, we also have relevant ministries and institutions that have been engaging in active role to promote the rights of the children. For example, the Ministries of Social Affairs, the Ministry of Education, Youth and Sports, as well as the Ministry of Women's Affairs and the Ministry of Health, along with the Ministry of Interior. Some of the subnational mechanisms that we included are among the followings: the Municipal Provincial Cambodian National Councils for Children, and the Advisory Committee for Women and Children, and the National Committee on Child Labor. They have been working closely with the Department of the aligned ministries mentioned earlier. With regards to the law on the protections of the children's status, we can confirm that the Ministry of Social Affairs are now currently in the process of reviewing and expecting to further receive feedbacks and comments from the ministers of the Ministry of Social Affairs, and then it will be further submitted to the Council of Ministers to be studied by the Council of Jurists sometime in June or July this year. They also expect to submit the draft law to the National Assembly for their endorsement by the end of this year. And we would like to highlight that this matter has been a great concern from our former Prime Minister as well as the current Prime Minister, as he pays strong attention to this law. And it is consisted of 14 chapters with 165 articles that precisely focus on the protections of children from violence, from family separations, from online exploitations, as well as from child labor. As for the legal provisions and mechanism to defend and preserve the rights of children in conflict with the law, it is covered in the law on juvenile justice, which was also mentioned by our colleague earlier and adopted in the National Assembly in 2016. And this has also been incorporated with the voice of development partners such as UNICEF, such as Plan International, and Save the Children, to name a few. So I would like to reassure the members of the committee that we take these matters seriously, and we are well underway to ensure that the draft law is coming into light in the near future. Thank you.
Thank you very much, Dr. Teo. One last note on the rights of the child, and with respect to Article 25 is concealment. And as Ms. Janina already mentioned, within our state report, as well as our response to the list of issues, we did mention that Article 333 of the Criminal Code specifically talks about concealment, states that the substitution, false representation, or concealment of the existence of a child which infringes his or her civil status shall be punishable from 1 month to 1 year. We believe that this adequately encompasses the 3 scenarios as mentioned in Article 25, but if there is a gap, we look forward to the committee's concluding observations and detailed comments as well. Okay, so I would like to move on to human trafficking and invite Excellency Izuki from the Ministry of Interior. On human trafficking, I understand there were a few questions from our distinguished members of the committee mentioning that on the numbers of foreigners. We would like to clarify, as I received information, perhaps there's a translation issue, but we would like to clarify that the number of foreigners, they were not victims, but suspects. So they were suspects. But nevertheless, now I'd like to hand over the floor to His Excellency Izuka from the Ministry of Interior, where he would like to discuss a bit about the measures taken to combat human trafficking. Excellency, please.
Regarding the question that you have asked about combating human trafficking in Cambodia, the first point I would like to clarify is that the involvement of civil society organization. I would like to clarify that the involvement of the civil society organization is voluntary from the organization, that we open for all for participation, but some organization did not participate consistently. Second, we have worked closely with those organizations that have registered MOU with each other. In total, 18 organizations, and organizations that have not been signed as MOU with us. Regarding the effectiveness of the response to the human trafficking, I would like to clarify that as we have mentioned before, apart from the legal provision, we also have MOU during 2003 and ratification in 2005 that we receive the prosecution of human trafficking. We have implemented the ASEAN Convention on combat against human trafficking, especially on women and children. Cambodia have special law to combat human trafficking and sexual exploitation. The fourth point, Cambodia have our strategic plan, 5-year strategic plan that we have mentioned before, that we have 1 year's implementation. Each year, we have been implementing since 2018, and we are updating the actions for 2024 to 2029. Another point, Cambodia have the clear structure to implement the law from the national to subnational level. Is the cooperation with the authorities, relevant authorities inside and outside of Cambodia, especially organization partners. Cambodia have been receiving a good results on this matter, and this cooperation is very necessary for us. 6th point, Cambodia have been preventing the human trafficking in any case under the advertisement of law. To provincial policies. I would like to clarify that this work we have tried to manage and work on this matter. It does not mean that we only do this work in the national level. The 7th point, the establishment of the information system from social media, from hotline 88117, and also a Facebook page to receive the information and respond and act to the victim anytime, and to arrest the offender according to the law. 8, Cambodia have been implementing the local policy, security, especially on human rights, women's, family violence. 9th, Cambodia has determined the identity of the victim of human trafficking under national law and international law. By considering on the rights and decision of the victim, by providing social, educational training, and also trainings, and also legal assistance. Cambodia has cooperated with countries in the region and also in the world to combat and prevent illegal cross-border, and to search for the offender on human trafficking. From all above points, Cambodia have done and also have been doing in the Cambodia will be doing in the future as well. Thank you very much.
Thank you very much, Excellency. I'd like to quickly touch upon questions regarding the ECCC, the Khmer Rouge Tribunal. As you know, the ECCC is a hybrid tribunal created from an agreement between the Cambodian government and the United Nations. So I'd like to touch upon 2 points with respect to the ECC. First, with respect to enforced disappearance cases, and second, with respect to reparations. So the ECCC's, under the ECCC's mechanism, reparations are provided to victims, civil parties, but also you could say to victims of the Khmer Rouge throughout the whole country on a collective basis. It is not monetary or personal, it is collective and symbolic. And the reason being is that the defendants, or in this case the convicted themselves, are indigent. And so you can't really provide monetary reparations. The question is, where would the money come from? And so reparations that have been provided to civil parties are around 20 reparations, and they are, again, collective and symbolic. They include, for example, stupas built across the country in various areas. They also include a public holiday for remembrance for civil parties and victims of the Khmer Rouge. They also include documentaries, awareness-raising programs, exhibitions, including what happened under this genocidal regime within the curriculum of high school and training of instructors and teachers to include them in the curriculum. And so you can start to now have a sense of the kind of reparations that the ECCC provides. They are mainly collective and symbolic because you could say that we have about close to 4,000, between 3,000 and 4,000 civil parties at the ECCC who applied to be part of the proceedings. But when it comes to victims, personally, I am the view that everybody in Cambodia is a victim even till today of the Khmer Rouge regime, even those who have not lived through it, like myself. So with respect to reparations at the ECC, it is made in a collective and symbolic manner. On the topic of cases of enforced disappearance, the Supreme Court Chamber in case 00202 found Khieu Samphan and Nguyen Chia, well, mainly Khieu Samphan, guilty because Nguyen Chia died after the trial, after the judgment of the trial chamber in case 002/02. But specifically, the Supreme Court Chamber in case 002/02 found that they took into account the evidence of many civil parties regarding enforced disappearance and found that there were crimes against humanity of other inhumane acts characterized as enforced disappearance perpetrated by Khieu Samphan, who was the head of state at the Khmer Rouge, of the Khmer Rouge regime at the time. With respect to the exact figures, those are not in the judgment, but nevertheless, the ECCC, the royal government, as well as civil society organizations and NGOs have worked together to compile information on victims of the Khmer Rouge. And all of this is archived. I don't have the figures with me today, but all of this is archived at not only at the ECCC, but also an NGO that is well known called DCCAM, which is the Documentation Center of Cambodia, who has been working with the Khmer Rouge Tribunal in gathering information regarding killings, tortures, and enforced disappearance, forced transfers, cases of forced marriages, and other criminal acts under the Khmer Rouge. One last point on the ECC is that the ECCC has transitioned into a residual mechanism, and under this new mandate, it is focused on archiving, and it is open to the public. I myself have visited many times. For this mandate, this mandate exists for a period of 3 years, so it focuses on archiving, and not only archiving, but projects for victims as well. I don't know how this project, what is the development for this particular project that I'm going to raise, but one that was discussed was to label areas across the country, campsites, so that they are places of remembrance of where certain criminal acts were perpetrated. So in terms of projects for victims and archiving, the ECCC's, under its residual mechanism, is also focused on keeping those records and still helping and having projects to assist victims of the Khmer Rouge today. One last point is they now have a bus that goes around the country to discuss about the legacy of the ECCC, as well as assist victims in various other ways and whatever projects they have. Okay. I'd like to now move on to regarding the question on the records and registrations at the Ministry of Justice, and regarding transparency and the ability to access such registration, which was raised by Madame Ms. Quintana. So on this note, I'd like to pass the floor to my colleague, Excellency Gideon from the Ministry of Justice.
Thank you, Mr. Head of Delegate. And we understand the question. And regarding the history of the detention and also relevant to this, because normally during the investigation is confidential. So normally we kept all information is confidential. Whatever the ministry get is just only is a kind of data of the case file. For example, I would like to highlight us a bit on human trafficking. We are one of the members of the National Committee to combating the human trafficking. We still have our record periodically, I mean 3 months, 6 months, and 1 year. And when last time we can have also divided, for example, we have how many cases under investigation, how many cases will send to the trial, and also how many cases has closed. So the data that we also collaborate with Ministry of Interior to collect all this information, and also so we have a list of data like this. We prepare and put in it in different, I mean, at the prosecution stage, at the investigation stage, and at the hearing stage. So we follow up and monitoring of all this process to make sure that the implementation of the register of those are well recorded and well organized. Thank you.
Thank you very much, Excellency. There were also questions regarding the victim's right. So on a matter that's similar to this, on the victim's right to receive information about the truth and the process in them filing for reparations in the form of restitution, satisfaction, such. And for this, I'd like to pass it forward back to my colleague.
Sorry. Once again, thank you, Heads of Delegate. Regarding the victim, I think we can refer to a few articles in that. Normally, we have a general rule defining a victim of a criminal offense as many persons who claim to be a victim of an offense can file a complaint. And we will recognize as a civil party, and the civil action shall be brought by a victim of an offense. And in order to be compensated, the injurer must be a direct consequence. It should be have so that there is injury, and they have a lien de causalité in French word. I mean, direct consequence of the offense, a complainant's personal damage occur and current, and injury can be a property of physical or emotional damage. And civil action can be filed on behalf of the victim by his or her guardian of the victim, if the victim is a minor, an adult under the law of guardianship. If the victim is dead, a civil action can be started or continued by his or her successor, Article 16 of the Criminal Procedure Code. For example, we can have also an association working for common cause and interest of the group of the victim, such as, for example, association for eliminating all acts of kidnapping, human trafficking, sexual exploitation, association for eliminating all the acts of racism and discrimination, for example. And in terms of how they involve in the process, when the victim is recognized as a civil party, I think the process is as what our head of delegate mentioned about the role of civil party in the ECCC, ECC. But the reparation different from the ECC because it's very difficult to compensate because as you know the Khmer regime every family are victim. Even myself, I lose one of uncle, but we don't know whereabouts until now. Where is he from? At that time, he was a young student at the university. When the Pol Pot regime entered into the Phnom Penh, he just only want to visit to meet his mother at the outskirts of the Phnom Penh. Then he lose. We don't know whereabouts. So a lot of victims in every family. So how you compensate? That's why the approach of the ECC is symbolic and collective compensation. So we have a lot of us, Excellency highlight. We have also few civil society work in order to. It's a kind of awareness of this sort of crime atrocity not to happen again. So and also in terms of the we can also have look at the practice and direction of the victim participation in the ECC amended in 27 October 2008. We define a victim as a natural or legal entity that have a suffer physical, material, or psychological harm or injury result from the direct consequence of the commission of any crime within the jurisdiction of the ECC. I mean, crime against humanity, genocide, war crime, whatever. This is definition of the victim. We have victim, and for example, they have, if they want to have a compensation, they feel they can file also with the criminal complaint. They mention whatever the compensation they want to get. But also, if they fail, they can also file after the case is finished, and we accuse the perpetrator, and then the victim can file a kind of civil complaint for compensation for the damage. So this is well established under criminal procedure code and criminal code, and also in civil procedure and also civil code. It's a comprehensive. Because we have looked at our social context of Cambodia, and also we get a best practice from our expert assisted from, I would like to highlight and thank you for the government of French for assist us in preparing the two code, criminal procedure and criminal code. And we have, thank you to Japan government for assisting us also expertise to develop also, but we from two code, civil procedure and civil code. Thank you.
Thank you, Excellency. I'd like to now turn to Mr. Kanyong Golo's questions. The first one was with respect to the human trafficking data, and the short and concise answer is that it is available upon request. And so if such data were to be requested from the Ministry of Interior or the Cambodia Human Rights Committee, it is available upon request. Now, with respect to, sir, your second question on training and the incorporation of enforced disappearances, I'd like to invite Excellency Pandada to elaborate more on this.
Thank you, His Excellency Head of Delegation, for the floors. Before I tap into the human rights training, I would like to tap on the suspension of the training for the judge and prosecutor. I would like to inform that because of the COVID-19, so they suspend the program, and the school need to reschedule the school need to prepare and design a new curriculum for the judge and the prosecutor. But now, regarding to the human rights training, mainstreaming of human rights and disseminated the rights is very vital. core of ensuring a better implementation of the existing legal framework in line with the international mechanism. First of all, the issue of the right is very complicated. It's a complicated issue, and it is an incredibly difficult task for ensuring the people at the relevant authority as well as public in the subnational committee to understand and the concept of to ensure the protection and the promotion of their rights, to ensure the implementation and what constitutes their rights. They can know what is their right, so they can seek the reparation or know what is next step to do to address the infringement, where to go, how to address the issue concerning their rights, what availability source for them to offer on a legal assistance, and so on. Further, I would like to emphasize that once we know our rights, we can say that the number of the violation of the human rights can be decreased once people know what they can do, what they cannot do. As enforced disappearance, we will incorporate the element of the crime as it is a comprehensive cover in our legal framework. Thank you.
Thank you very much, Excellency. I'd like to now invite Excellency Isuki from the Ministry of Interior to address Ms. Lochbiller's question regarding, which is a question from yesterday as well, regarding civil society organizations and the law on NGOs.
Respected Chair, ladies and gentlemen, regarding the association and non-governmental organization, Cambodian government have been focusing on this problem about the association and non-governmental organization in the local. They have the freedoms, full freedom to act in Cambodia in accordance with the law and existing legal provision. Also, there are criteria that has placed in the Ministry of Interior. Association and NGOs in Cambodia that have put their case and register in total 6,309 case, and association in total 2,770, and NGOs in total 3,539 organizations. After the law of association and NGOs organization have been into force in September 2005 until now, until January 2024, there have been association and NGOs that have registered in Cambodia in total 1,804. Association in total 1,033, and NGOs in total 771 organizations. To better the action of the organization, the government have decided to prepare the partnership between the government and the NGOs and create the working group of the government to coordinate the request and comments of the civil society. To receive the comments and feedback from the civil society organization that have been reported to the government under the purpose of partnership, honest partnership, and legitimate partnership. Simultaneously, we also put instruction dated in 2008 and another one dated in 2023 to ensure that the association and NGOs and committees in the local have full rights to act in Cambodia in accordance with our law and existing legal provision. In this sense, our government committed to prepare the partnership between government and NGOs and civil society at least 2 times in a year to go hand in hand with each other to promote human rights and to develop our economy with the involvement of all parties. In the second semester in 2020 and 2021, the preparation of this have been delayed because of the COVID-19 pandemic. Under this sense, in 2023, the Ministry of Interior have prepared the partnership between the government and the NGOs to prepare this, to discuss the non-governmental organization and with other stakeholders that work in the local area about the amendment of the law on the association and NGOs. After we end the discussion with relevant NGO stakeholder 6 times, the government working group have reserved the feedbacks and comments from the civil society, have arranged a meeting continuously from 18 September 2020 to 13 September 2021 to review and study on the substance of the request to amendment on the 14 articles on the law on association and NGOs. In accordance with the national law and international standard, and also the experience from other countries, and also the practice from the past, to ensure that the draft law is in compliance with the development of the country under the purpose of protecting the people's interests and also public interests, and also to promote a collaboration, partnership between association and NGOs with the public servants. In 2022, the Ministry of Interior, with the government working group to coordinate the requests and feedback of the civil society, have continuously discussed with the representative of the civil society that have been participate from the embassy to review and discuss on the draft on amendment on 16 articles of the law on association and NGOs. The first article, the Article 7, Article 8, Article 9, Article 10, Article 11, Article 20, Article 21, Article 24, Article 25, Article 26, Article 30, Article 31, Article 32, Article 35, and Article 36. As a result, the meeting agreed on the content of 9 articles, which include 7 articles, including Article 9, Article 10, Article 11, Article 20, Article 21, Article 22, and Article 36 that were requested by the civil society for further internal review by themselves before submitting the final comments to the Ministry of Interior for consideration. But to date, the Royal Government Working Group has not received the promised comment on the amendment yet from the civil society. Currently, I would like to clarify for Cambodia that with the civil society, we have to reinforce the democracy. Thank you very much.
Thank you very much, Excellency. So, members of the committee, as you can see, there are many NGOs in Cambodia, and we are currently in the process of amending the law on association and NGOs, also called LINGO, with participation, full participation from civil society organizations. I'd like to turn to I understand that we're running out of time, and so I'd like to pass the floor to Mr. Chair. Thank you.
Merci beaucoup.
Thank you very much, Your Excellency, and thank you to your delegation for all these detailed responses. We had a little bit of extra time in hand, and I think we made good use of it. It's given you the opportunity to respond to many of our questions. We now have a little more than 5 minutes left before the closure of the meeting. I'd like to begin by turning back towards you, Your Excellency, to see if you have any concluding remarks you'd like to make, and then I'll make some concluding remarks of my own. So if you could take just a few minutes to make any concluding remarks.